Okay, so for all of you who have joined us, welcome to this month's Fiduciary Education Forum event. My name is Todd Wohl. I am with Braun International and Premier Estates, International Real Estate. We host the Fiduciary Education Forum. It is a monthly event. And for those of you who are new to our presentation, we do have a brand new website that is available. It's called fiduciaryforum.com. That's fiduciaryforum.com. And this website is all about education for the fiduciaries in the estate trust world, and experts who need and want to be educated by expert professionals. It is an organization we're very proud of starting about 1.5 years ago, and you will find in the fiduciaryforum.com a video history of the different presentations, or some of them that we have had experts speak on different topics relating to your industry and business. Additionally, there on the website is places for you to ask questions, post questions, and then also if there are different types of presentations in the future you'd like to learn about, we'd love to hear from you. Absolutely, on other ideas that you'd like to learn about, we'll find the different experts to present on them. And again, Fiduciary Education Forum event is monthly through just about every month this year. And anyway, well, welcome. And I want to get started. I want to make the introduction to our keynote speaker today, who is Michael Williams, and he is a PPF with Williams Fiduciary. Also, Michael is a licensed California contractor and has decades-long experience regarding contracting as a contractor in California. And Michael and I had the opportunity to actually discuss our presentation, our event at the Fiduciary Conference a few months ago. And when I learned that he was a contractor, I was really excited, because having both the fiduciary expertise and the background in as a contractor, for many of you fiduciaries who are involved with real estate know the perils that you put yourself into every day, making the right decision for your client, but also for your own business, and protecting yourself in those situations. So our topic today is what to do and what not to do when repairing, renovating, stabilizing real estate, a fiduciary and licensed contractor's perspective. Michael, how are you? Would you like to give a quick background on your expertise, not just as a fiduciary, but as a contractor, before we get started?
Sure. Thank you very much, Todd. I'm Michael Williams. I've been a licensed fiduciary since 2016. I've been in the construction trade since I was about 15 years old, so over 30 years. I'm no longer a contractor, but I held my license for about 15 years straight. Prior to that, I built a lot of custom houses, did some military work, some commercial work, kind of all well-rounded type of construction background. I've seen quite a few things here and there, seen the ebbs and flows in the economy where construction was booming and construction crashed. So I brought at least to the fiduciary world, kind of a unique perspective. I don't know of any other fiduciary that came from construction background.
Yes, I agree with you. Your background is really a tremendous value, and I suspect after this presentation, you'll be getting a lot of inquiries and calls from other fiduciaries. So we're going
Probably
to
so.
get started on the presentation, and everybody, please follow along. Um, so what is know your role? What does the trust or authority say? You know, in regards to your authority to make any types of repairs, renovations to a property. And you know, I do want to just kind of uh, say one thing. This presentation is applicable to any type of real estate. It might be residential, it might be commercial, it might be office, it might be retail. It doesn't really matter what type of property you're dealing with or have to, in our world, stabilize. Um, you know, for us, we want to make sure, and our focus is protecting the fiduciary from making wrong decisions during the process um, of analyzing what they should or shouldn't do. So, Michael, on this first page, do you have any comments about you know, knowing your role?
Sure. The first thing that I think is very important is that you're an office holder as a trustee, right? You can be replaced. Somebody can take that position after you. They're entitled to all of your documentation and notes and work. And that puts you in an interesting position in that you don't get to take your work with you and bury things and hide. So you need to keep in mind that you are just the trustee. You've got a defined role, and anytime you're outside of that defined role, you put yourself in jeopardy. Your attorneys can no longer protect you. Your beneficiaries and contingent beneficiaries can attack you when you're outside of your role. So that's really important. The second part is that you really need to be familiar with whatever your authority says. If you're working under a trust, you need to know what the trust defines as the trustee's authority. If you're working under a power of attorney, you really need to have that specific document from the principal that says, I want you to do this task with this real property, not just a blanket POA and go ahead and remodel the property. Or if you're a conservator of, or something along the lines of a court authorized, you really want to know what your little box is and stay in that box. Don't be a hero. Don't try to make the world a better place for everybody. That's not your job, and you really want to stay in your box.
Got it. So, Michael, when you talk about responsibility to beneficiaries, this is a problem we constantly see when we advise or consult with fiduciaries or trust companies, whether we're going to sell the property or help stabilize it or provide funds to repair the property, which we do. You know, talk about the responsibilities. You know, what you see on this page, and to me, what seems to be most relevant is timing. Taking the time, you know, conditions. I'll let you time away.
Sure. Thank you, Todd. Timing is very important. The time between conceiving of a project and getting the project to completion can be very long, depending on the scope of work. If it's a commercial project, it could take quite some time in development before you actually get the project rolling. The market can change on you if you're expecting whatever work you're going to do to increase the value of the project. You need to be cognizant that say, for instance, recently interest rates went up on a commercial property. Your loans are about 15 years long, and then you have to get a new loan. If the interest rates go from 4% to 8%, your calculations are completely different. And you certainly don't want to be doing a project that's going to lose the beneficiary's money without some good just cause of why.
So that's a good point. And I can give all of our viewers many case studies in the work we do, trying to help a fiduciary or trustee or trust company, whomever it might be, to make the appropriate decision. But one of the things that we want everyone to look at or consider when they take on a property, that the beneficiaries are pressuring them to make repairs, to make adjustments to the property. I think one of the first things that we focus on is the cost. So we will provide a cost analysis to help you determine, if you're going to spend $1, are you going to get $2 back? And then what is the timeline for that work to happen? And then to Michael's point, what are the risks in the market for that time to occur, right? What could happen over that time frame? Because as all of you know, and for some of you who do know me personally, we have a very large development background in our companies. We develop properties throughout the state of California, of all shapes and sizes. We are not licensed contractors, but as developers and speculators and risk takers, we, on our own account, are always concerned about where the market's going and what impacts those could happen. And as Michael said, interest rates are just a simple example. But the other is the trades, how long it takes to actually get things done and to get permitted and to get approved and finalized. Meantime, the beneficiaries are waiting for their check, they're waiting for their rent, their income, their distributions. And you've made the decision, maybe on your own or maybe through a NOPA, to do this work. So there are so many factors that have to be considered, and those factors will vary, of course, based upon the property. And I think that's the most important thing that you all want to think about is, firstly, how are you protected through the process? So, Michael, talk about the ROI on projects. So talk about these items here.
Sure. So the ROI is the return on investment, right? There needs to be some kind of benefit for the beneficiaries, which is why they're called the beneficiaries, right? They're the ones getting the benefit of your actions as the fiduciary or the trustee. So if you have a beneficiary that needs to have some work done because now they're going to live the rest of their lives in a wheelchair, that's pretty easily justifiable. If you need to do some ADA compliant entrances and bathrooms, maybe put hard surface floors in and take the carpet out, that's all really easily justifiable. However, I'll give you a for instance. I had a potential client that I was interviewing, and one of the things she wanted to do was to rip the travertine floors out of her house and replace it with some other hard surface tile in a large format. And the travertine tile was approximately 5 years old. So in that case, she had some contingent beneficiaries, which you need to be very cognizant of because they do have rights also. And so there was no justification to do that change other than her tastes had changed. And as a trustee, I just couldn't justify that thing. So how's this going to increase the asset or be a benefit to the beneficiary? The benefit there in that example was she got to match her tastes. Was there an increase in value? No, I didn't see there was an increase in value. I saw that there was a lot of cash going out and time that we may have had to move the beneficiary into different living conditions. And it just wasn't justifiable. And part C, should you get an appraisal to justify your thought process? And I think that on larger projects, that's a very, very good idea. On large commercial projects, let's say, that's mandatory, that you get an appraisal to know what that property is worth when you're making your decision process happen, and what it's going to be worth when you're done. You need to be able to justify that. And sometimes an appraisal is the only way to do that.
So let me chime into that point,
Sure.
and that's a very good one. When you talk about getting an appraisal, of course, for everybody who's on this presentation, some of you may or may not know that we are licensed real estate appraisers, and have some of our team has a construction background and can do construction cost analysis. And doing the appraisal for the, let's call it the before and the after results of the appraisal of the work that would be done, that's called a hypothetical analysis. The initial analysis or initial appraisal would be the current fair market value as is. So an appraiser can provide you with, assuming they have the skill sets, they can provide you with the information and data points to help you make the decision. And with a licensed contractor, getting the information as to those costs to do that work. And I think most importantly as well, again, thinking about the timeline to get the work done. And how does that impact the marketability of the property if you intend to sell it, or the costs that are going to be incurred? How do you fund those costs for that renovation work? Again, something to think about. Michael, talk about costs.
Sure. Thanks, Todd. Cost. You need to know if the work you're getting done is priced correctly. The only way that I know of how to do that, unless you have a library of books that show you what average costs are across the United States, which I used to have as a contractor, is to get multiple bids. Traditionally and ideally, what you would like to do is get 5 bids and consider the high bid and the low bid to be throwaways. Those people probably didn't put enough effort into their bid. You don't want to take the low bid because they've certainly missed something critical. The high bid probably doesn't want to do the job, and their profit and overhead is too high. So take the middle 3, and then you want to see how you can compare those apples to apples. See what kind of verbiage they've provided you in the bid. See how you can compare those 2 or 3 bids. And if you have questions, go back and talk to the contractors, have them elaborate. Find out if this person is going to do the same kind of concrete work, if they're going to do the same kind of finishes, if it's the same kind of roofing. That's going to be your job as the fiduciary in this case, who owes a responsibility to your beneficiary to do the work right. You have to figure out how to qualify those things. There's no real one set way of how this gets done, but you're going to have to put in some effort, do some homework, and verify these things somehow. My suggestion on doing this would be to make some notes where you've compared things, and you can explain them in your notes so that if you ever had to go justify your position, you could just easily pull those notes out and say, this was my thought process. I questioned these ideas. I questioned those methodologies. I questioned those products. They seemed equivalent, or they didn't seem equivalent. I liked this contractor because he had a better breakdown, it was more detailed, or I liked this contractor because of the price, but you're going to have to figure out what you're paying for and how much it costs, and then justify that cost somehow.
Understood. I'll speak from a developer standpoint, working with contractors as we do, big and small. We have done in many situations for fiduciaries, we have actually reviewed their contracts with their contractors and give them a few pointers regarding, what's not said. And, I think the problem with getting work done today, even if it's, I hate to say it, a simple paint job of an interior and exterior of a home, what are they doing or what are they not doing? And
I think you're right, Todd. What they're not telling you is generally more important to your position as a fiduciary than what they're telling you.
That's right. So we've fortunately had the opportunity to advise some fiduciaries on just those points of what's not in there and why not. And it's very difficult for a fiduciary who doesn't understand real estate, who doesn't understand construction or repairs. I mean, you're put into a very difficult position, and that position is making you have to make honestly 1,000 decisions when it comes to making renovation, repairs, updates, and so on. And I'll talk about that towards the end of the presentation, as well as give a very good case study. But yes, understanding what is in the contract and what is not in the contract is going to help you really well. So there's no surprises down the road when there's that typical change order. Oh, you didn't tell me you wanted this done, and it's another $15,000. And of course, then which is very common to happen, right?
You were late to the party.
That's right. So verification, Michael, this is a big one. Why don't you talk about this?
Sure. There's a very easy way to check on a contractor's license. The California State License Bureau, where the fiduciaries all get their license, they have a contractor state license board, and they verify licenses. You can go see if they have any dings against their license, if their license is active, if they have any workers' comp claims. Things like that are all readily available, and you need to go check and make sure that they're licensed. The second thing is, in California, a contractor needs to have a bond. So a contractor's bond is a surety bond that guarantees the contractor is going to perform appropriately. And it's low-hanging fruit to rectify the situation for the client. So that's the first thing that you would attack in a challenge to the contractors. You would claim that bond, $15,000 or something like that. And what you want to do is get a list from that contractor about their past clients. Try to phrase your request in such a way that they're not going to cherry pick them. You don't want to know about their happiest clients. You'd really like to talk to at least one client that wasn't absolutely satisfied, so that you could get their take on how they resolved the issues, because that might come up. Construction is like a relationship, not so much in commercial, as Todd can tell you for certain. It's more transactional in commercial real property, but in residential real property, you're going to have people inside a house. There's personal belongings in there. The beneficiaries might be living in the house while the construction is going on. You really want to make sure that everybody's going to have a happy, trusting relationship. If you don't feel good about the contractor for any reason at all, whether it's their employees or their subcontractors, if you don't like their hair or whatever it is, that might be a sign that that's not the contractor for you, just because they gave you the best price.
One thing
Uh,
regarding, trying to talk to past clients, getting referrals from the contractor, which is not always an easy thing. I'll tell you, a very easy place to find out today is social media.
oh,
And, looking on social media, whether it's Facebook or whether it's LinkedIn, there are ways to learn about the contractor's background and capabilities. The other old school approach is the Better Business Bureau. That it's still a viable, definitely a viable consideration for a background check for sure.
mm,
But you definitely want to get some background on the contractor. And I'll be the first to say that in this market that we're in currently, and the difficulties it is to get contractors and their subs out to get the work done, it's a combination of pulling each hair out of your head because you got to get the right person to do the work. You got to make sure they're doing the work. You got to verify that they have a reputable background. There's a lot of requirements that you have to juggle. So social media and the BBB and again the licensing board are easy starts to getting some information quickly. And I'll tell you the other one, other than social media and Google, would be Yelp. I think Yelp is also a place that some people post good, bad, or indifferent comments. And sometimes when you're looking and reviewing these comments, you take some of them with a grain of salt. It just use your best business judgment in that regard.
yeah, one thing I'll say about social media is as a contractor, I really didn't like it. It's kind of a 10-to-1. So there's going to be 10 bad comments for every good comment. So you need to know that going in. You can't just read, 8 bad comments and think that person's bad, although that's a trend, right? If there's only bad comments, that's a trend. But you really want to look on social media for things like how did they resolve issues? The BBB, on the other hand, that's an organization to join. So like AIA for architects, right? That's an organization that a contractor would join and pay money to every year to get that little seal of approval. Just food for thought.
So good. Thank you, Michael. So now let's talk about a little bit more of like I like to say contracts, the meat and the potatoes that we've alluded to here. And so number one, does it protect the fiduciary or expose the fiduciary? That in itself is a red herring. Again, when you're signing a contract on behalf of, whoever you're representing, it is, of course, then your responsibility to make sure that contract is there to protect you and everybody you're representing. So having an attorney review it, and I'm going to tell you right now, it is not a typical trust and estate attorney. It is not a standard business attorney. This is an attorney that has real estate and a contract defect expertise.
Mm-hmm.
And there are law firms that specialize in this. And yes, it is worth every single penny to have that attorney review it. And again, it's kind of the same thing we talked about before. They're going to tell you as much what's not in it in the contract that what should be in it.
That's right.
And we can make recommendations for those types of attorneys anywhere in the state who have those, those credentials. So and by the way, that contract, whether you're doing a $5,000 paint job for the inside or the outside of the house, or you're doing major plumbing and electrical repairs or roof repairs, and that's $20,000, you're going to say, oh my God, I've got to have a lawyer review the contract. I've got to spend all this time and money. And that becomes that decision on doing it or not doing it at all. But again, whether it's a $5,000 job or a $250,000 job or a $2 million job, you still have to do the same and have the same protections, right, Michael?
Absolutely correct, Todd.
Yeah.
Absolutely.
You know, Michael brought up number C in this presentation. Does it show that they're making a prudent profit, right? So C and F are relevant here. For those of you who aren't familiar with how contractors bid, some will bid at a fixed contract price based upon the scope of work outlined, and some will do percentage based or what's called cost plus. I'm sure Michael could sit on this presentation and for 3 hours talk about the pros and cons of both.
Easily. Easily.
I can do the same, and I'm involved with 3 projects right now. 2 are fixed based and 1 is cost plus. And I can tell you there is not one better than the other. The difficulty in the fiduciary world is in a fixed contract. If you do not have the line item of scope of work typed out in bold from line number 1 to line number 4052, you're going to have a change order.
Right.
And that change order will be a surprise and an unhappy one. So I have generally found for fiduciaries, the ones that are willing to do this type of work, a fixed contract is not to their benefit because the contractor's waiting for you to make a mistake. Meaning, I've got to fix this. I've got to change that. We decided to do this. We found this problem in the property. Now we have to address it. And then the contractor's going to say, well, that's not in their scope of work. And now that it throws the pricing, then you have to negotiate. And by the way, you can't go out and find another quote or another bid for that work because the licensed contractor is going to say, well, we have subs that we use, and those subs are the ones we use. We're not going to use a sub from another company. So you're stuck. Your hands are tied.
Yeah, it's much like getting into conservatorship. Getting in is much easier than getting out.
Wow, well said. Well said.
Todd made a really great point there. Percentage based versus fixed contract is really important. Unless you have some very deep construction background or your attorney will help you produce a line item list that the contractor is going to sign an agreement to, percentage based is most likely your best way to go, because contractors compete on getting jobs by the lowest bid they can possibly put out there to ensure they're going to get it. And the way they make money, whether it's federal, civil, or residential, is change orders. In a fixed contract, you're going to have a lot of change orders.
Well said. Well, let's see. I think the other point I'd like to talk about here, just real quickly, so I make sure we get through this presentation, is point of contact. Now, we just got involved with a fiduciary who was going to do a tremendous amount of work to a single family home, and luckily we were referred to this fiduciary who we'd never worked before, and this fiduciary was potentially sold a bill of goods from a company that said they were going to renovate the property and do this work on hand, and they were responsible for doing the work. And in the end, all the fiduciary had to do was sit back and wait for the work to get done, and reap the rewards for their clients, the beneficiaries, and the trust, and so on. And luckily enough, we were brought in to do a quick analysis based what we said before, which was the before and the after, right? What was going to be spent and what was the benefit of what was going to be spent and what's the time to do that. And after we looked at it carefully, the risk versus the reward of about a $50,000 benefit, it was clear to everybody that it was not worth it, not one iota. And quite frankly, the only people that were making the money were the company that was actually going to do the work. And so we were able to help the fiduciary make that decision. And so again, it's all a matter of analysis before making a decision, but also not to a point where the analysis becomes paralysis. Going back to this page, I know I just went off on a tangent a little bit, but the point person during the actual process of the renovation work, who is it going to be? Is there an on-site job supervisor? How often is the contractor going to report to you? How are they reporting to you? Are they giving you emails daily of updates? Is it a weekly report? Is it a phone call or a text? You know, you can't expect to be on site and watch what they're doing. You're relying on the contractor to do it. So how is that being done? That's a given. I think the next point on this page, which is a biggie, and unfortunately I have been through it personally, is how do you handle disputes? Are they handled in contract and arbitration? You know, again, this is another presentation unto itself, but you know, Michael, from your perspective, do you want to talk about disputes quickly?
Sure. I can tell you that when I was a contractor, every one of my contracts said arbitration. That's basically sitting down with a mediator and arguing your point versus the client arguing their point. But the point here is you want to know what the contract says about how to resolve disputes, right? If you think the contractor is not performing properly, how do you go about maybe stopping the work and changing their direction? You want to know that upfront in the contract, in paper, so that you could just go down that road. There's no sense in arguing with a stubborn contractor who keeps doing what he wants to do, and you're becoming less and less happy, and it gets right to the end, and then they say pay up, and you say, well, why have a problem way back from the beginning that we need to resolve? And you've done all this work on top of it. So you need to have that process right in front of you. Hopefully you'll never use it. I never went to arbitration one time, so I don't think it happens often, at least not in the world I traveled in. Probably won't happen often in fiduciary land, but you need to know how to handle disputes.
So one thing I would say, you first want to mediate, then you want to arbitrate. Mediation hopefully will resolve the problem and resolve the problem quickly. Because if you're mediating after the fact the work is done, then you're mediating regarding payment. If you're mediating during the course of process, I can tell you right now, you got a big problem. So arbitration is the secondary approach. And then finally, of course, is court, which nobody wants to deal with.
No.
So I always say start with mediation. If you ultimately get to that point, and if you've gotten to the point of mediation, I'm going to tell you, it's going to be very, very difficult for that contractor to complete the work if he has not or she has not done so. Just to the point that you can't resolve the problem verbally. And I'll tell you, you want to bend over backwards to try to make the relationship work, even if you're really pissed off with this contractor, because your goal is to get the work done, get final, and then deal with the problems after the fact. You know, regarding payment, this is another issue we had with a fiduciary last year. All of you can see the different lines here. But the number one thing I've learned with fiduciaries is they have no idea what a lien release is. And getting that lien release has to be done over progress and time. So there's a blanket lien release when the project is completed, but if you're going to fork over money during a progress payment, right? So if you're, whatever it is you're doing, you're paying over time, you're never going to give the contractor a lump sum dollar amount at the beginning of the contract. And if ever contractor ever asks for that, never work with them. But you'll pay them over time. So as that money is paid, you need to get partial lien releases, right, Michael?
That's absolutely true. That's the only way you want to do it.
And then of course the final, and again, this is a biggie, and I get caught up in it myself when we get involved with properties, and that is you've got to make sure you're holding back money from the final payment amount that is due. And that final payment amount is not due until you have final permits signed off by the city.
That's right.
You have the quality of the work that has been expected to be done has been done, because those are two different things, everybody. The permits could be signed off, but there's crappy paint work, there's crappy millwork done, the flooring doesn't look perfect. Well, you want it done right, you got to hold back 10%. And I can tell you 10% is at a minimum the profit for the contractor plus. So while you're holding back, they've got to get the work done, so you get that final payment. But at the time you give that final payment, you have that complete lien release in front of them. When you give them the check, they've signed the lien release. Because for those of you who don't know, a mechanic's lien release can be and is the first thing a contractor can put against title on a property. And as such, and we've seen this happen a couple of really bad times, that some fiduciaries got into some unfortunate situations where they had no idea that there had been a lien put against the property, and the lien had never been pulled off title. And we were brought in ultimately to sell the property. And here was a mechanic's lien that was a year or 2 years old. And now the mechanic's lien, the contractor, is almost in a blackmailing perspective, right, Michael? Right? Because
very true.
You've got to pay off that mechanic's lien to get title cleared.
Sure, and that contractor could have gone out of business.
That's a great point, Michael.
I mean, it's really hard to get them to sign paperwork if they don't exist.
So, and that goes to another point. When we take on a property that we're going to sell or potentially sell, the first thing we do is pull a title report, because that title report will tell us where are all the spiders in the closet and the ghosts in the closet. And that'll tell us if there are lien issues, if there are easement issues, if whatever it is, we pull title right out of the gate. But making sure that there are no potentially any mechanics liens put against the property, you won't know that until you actually pull title. So, larger construction companies, they have a very solid process from start to finish regarding payment and lien release as process goes. So if you're talking about, a large retail shopping center, an apartment building, and the type of contractors that work in that field, you're going to see a far more professionalism than you are for the contractor that's going to, renovate or remodel 4 bathrooms and a kitchen and the floors of the house. So you want to just keep that in mind. Another thing, Michael, you want to talk about an additional insured?
Sure. Not only should your contractor of choice have insurance, that is appropriate for the project you're working on, not just the work itself, but the total value of that piece of property. You need to have the trust, and specifically you as trustee, listed as additionally insured. The trust will cover the property because ostensibly in this example here, the trust owns the property, which is why you're working on it. But you need to cover your little butt by having yourself listed as additionally insured. You can also list the beneficiaries of the project if they live inside the project. You may consider having insurance on the construction insurance policy in addition to being listed as additionally insured. You can do that if you feel that's necessary. If you feel that there's plenty of stuff in the house that could get damaged. I've had clients where they had collector cars and we were working in the room above the collector cars. So when I was working on that project, I pulled out insurance on those cars because the client would not move them. So, you know, these are things you want to think about. Put your eyes on the project first and make sure you are insured appropriately.
Yes. That's a biggie. And I can tell you, the first thing we do when we sign a contract is we get named as additional insured on the contractor's policy.
Yeah.
And I'll tell you, making sure that the contractor has a policy in force and that it covers the myriad of their scope of work that they're providing you, that's important unto itself.
That's correct.
And if they have workman comp, so if they're hurt on property, then you know they're not their trades aren't coming back against you. You know, very, very important. We talk about permits and getting permits and inspections. Here's a common question. Todd, do we really need to get permits done to you know, to renovate the bathroom? Todd, do we need to get permits done to paint the house? No, you don't need to get permits done to paint the house. Todd, do you need to get permits done to renovate the bathroom? Yes, because now you're talking about plumbing and electrical subcontractors who ultimately, if their work is shoddy, could create more problems with the work that they did than the work that needed to get repaired. So permits are very important, but I think as Michael would attest, by getting the permit, you are now getting inspections. And the inspections from the city, even though they cost money and they take time, the inspector is there to make sure the contractor did the right job.
That's right.
So it's a little bit of a backstop. But I'm going to tell you, we have a house we're selling right now that was in a fair state of disrepair, had cracks, had fireplace issues, had dry rot, had bad plumbing. And the beneficiaries wanted the work done and wanted the fiduciary to do the work. And luckily, this fiduciary was very smart, very savvy, and even spending that $50,000 or $60,000 that the estate would have had to spend, the time to get the work done that needed to get done was probably 4 to 5 months, because the fiduciary knew that they had to get permits, and the contractor had to pull permits and get inspections for the work done. Well, ultimately, the beneficiaries in that example decided, okay, we shouldn't do that because we want to get the house sold. Well, we thought this could all get done in 4 weeks and the work would be done magically in 4 weeks. And isn't this great? And then we can get the house sold in a matter of, 6, 8 weeks. And they realized it wasn't the case because the fiduciary was doing the right thing. They were going to get permits, they were going to get inspections, and they were going to go through the bidding process and so on and so forth. So getting permits is critical. What you get the permits for again, roof, plumbing, electrical, foundation, windows, engineering, structure, uh, you know, even HVAC systems, right? You get a permit to put in an air conditioning system, right? Yes, absolutely. I know Michael could sit and talk about example after example, but what not to do as I could. Unfortunately, we don't have a lot of time.
Yeah, we'll have to keep moving, but
yeah, this is key. Here's another topic when we talk about construction, and that's disclosure. I know you are all barraged with what should you disclose, what should you not disclose, and we're only talking about this here because if you're going to do work on a property, well, that work obviously has to be disclosed. And there's not a question about it. You want to disclose what you did because it's to your benefit. We're selling a fourplex right now for a fiduciary. And in this case, there was water damage inside the house from an exterior planter. So we had mold, we had water damage inside the house, and that had to be repaired because there was legitimate mold. And one of the reason we knew it because the tenant got a mold report. So we had the mold report, the work had to be done, and we then got a mold clearance report. All of this was disclosed to buyers when we went and took the property to market. But I'm going to say to you and go on record here that there's ways to disclose and there are ways not to disclose. And we're going to have a presentation regarding disclosure as a separate FEF presentation in the near future. But one thing I would say to all of you who are watching, if you have an email from a beneficiary, from a partner, a family member, anybody that had any information about that property, and it was just in writing, we think that there was some water damage in the kitchen in 1982, disclose it. Well, we heard from the tenant that there's a varmint problem or a rodent problem that seems to be reoccurring, but you have no report, disclose it. Disclose what you have in writing, what's been emailed to you, what's been texted to you. Write a book, write a Bible when you report your disclosures to your real estate agent or broker. And we will help you do it, and make sure you write all that down. And even if it's hearsay, you've made the statement. You're protecting yourself. Because most real estate agents will say to you, just sign the exempt seller disclosure. You don't need to provide an SPQ or a TDS, just sign it. And then guess what? You had information and you didn't disclose it. Well, now you're really in the line of fire. And we could, again, that's a whole nother presentation. So I want to go back just with a few more minutes here and talk about a simple case, a case study, and what you fiduciaries are being barraged with. And I'm speaking very candidly because we are developers and because we lend to fiduciaries who need money for illiquid estates, in addition to all the other things that we do. We have had fiduciaries say to us, Todd, we need $300,000 or $200,000 to make repairs to the property. We have this company that said they're going to do all this work. They may be willing to advance half of the funds. We put up half of the funds, and then they're paid when the property is sold. Well, I have been a very long believer, unless the work that you're going to do is at a minimum of a double, meaning the cost of the work, and then the profit is a double. And the time that it takes to get that work will, in our belief, not impact the value of the property. Then that should be at least considered as an option for the trust. But I would say to you generally, Fiduciaries should do no work to a property. They should not partner with anybody to do the work. They should not allow anybody to do the work on the property, even if they're advancing all the money and getting it back at close of sale, because there are companies that provide that as an option and as a tool to actually get the listing. We provide the funds, we can provide expertise and advisory, but we will never ever partner in remediating a property to sell and be the broker of record, because it's an inherent conflict. But more importantly, you run the risk of real problems down the road that are truly unknown to you today. And then a year from now, or 6 months or 4 months from now, you look back and you say, why did I ever do it? Because you're trying to be the good person as a fiduciary and add value for the beneficiaries, but you're not a contractor. You're not in the profitability business to make a profit. You're in the business of managing the situation as it sets forth in front of you. And I highly, highly suggest that before anybody on this call decides to make any major renovation work or have somebody do it for you, whether it's a contractor or a company that's going to do it and pay for it and then be paid back at close, that you talk to your counsel, you talk to companies like us, and get advice and at least feedback before you make that kind of decision. Michael, do you have any opinion on that?
Sure, Todd. I also would second Todd. I don't recommend doing work on beneficiaries' properties unless you have to. Now, things like I mentioned before, if you have to bring a property up to ADA compliance because now your beneficiary is handicapped for a long period of time, that's a completely different thought process. I think that's a pretty easy one to do, provided you don't have to spend all of the treasure in the trust to make it happen. But generally, I would stay away from it. I mean, there's ways around it. Selling a property is always a good way to go. Discounting the price for the work, but it's always risky to do construction if it's not your house, right? Because you have to defend your thought process, which is very difficult to do if it goes bad. And like Todd said, a lot of times these things come back 1, 2, 3, and 4 years down the road. And if you don't have very good notes and you're standing in front of a judge trying to explain why you did some work, but you can't reference notes right in front of the judge and say, this is what my thought process was, and this is how I came to this particular conclusion, you're likely going to take it in the shorts. It could be really bad. And you are responsible to make it whole. So whatever it costs to make it whole, that judge can determine you're responsible for that.
And remember, everybody, in closing, a contractor's warranty, unless it's brand new construction in the state of California, SB 800, which is the bill that requires a contractor to provide 10 years warranty for new construction.
Yeah, on all structural.
On all, that's right. But if they're just doing remodeling work, the warranty is pretty much as it's offered by the contractor.
That's right.
And so a year and a half from now, the warranty is expired and a problem pops up. And who's on the hook? The fiduciary, the beneficiaries who own the property at the time of sale. So, and I will tell you right now, I hate to do this in closing, but right now, as we are involved in a major lawsuit that a buyer is trying to sue beneficiaries and fiduciaries and everybody involved for the purchase of a property of which they had done all their work, received all the reports on before they closed escrow, and then found that there were more problems in the home and have come back and decided to sue everybody because they can. Not because the fiduciary didn't do the right job and the real estate agent didn't do the right job and all the disclosures were correct and the reports were correct, that was all done properly, but you still can get sued. And that's what's happening. So now, to Michael's point, you got to go defend it and take your time and money. And so preparation and caution, I think, is the caution, I would say, is the key word when making any kind of repairs to, or deciding to make any repairs to a property. The word would be caution. Caution before you decide, right, Michael?
That's very true, Todd. Caution is the key word.
Is the key word. Well, look, I want to say thank you to Michael for taking this time and to all of you for being part of this. Our next presentation will be at the end of September. We are going to have a number of panelists on regarding fiduciary accounting and finance and even possibly forensic accounting. So please check out our website at fiduciaryforum.com. We're happy to send you this presentation. It is recorded. It will be available on the website if you want to watch it again. Reach out to Michael Williams. His information is in front of you, and we're happy to send his contact information. If you have any questions, reach out to us. So I myself and our team, and throughout California and the country at Braun International, Premier Estates, we just want to thank you for being on this. And if you all have any ideas, any presentations that you want to learn about, please send me an email or a text or post, whatever it is, and we're happy to talk to you about some of these ideas. We're always on the hunt for great topics to speak about. So, Michael, thank you so much, and thank everyone for this. And we will look to see you soon, and have a great rest of the month and a fabulous Labor Day. And we'll all see you soon. Thank you all.
Thanks, Todd.
My pleasure. Thank you so much. Take care, everyone.